Mama's in the living room watching Judge Judy. I'm in the kitchen eating leftover sushi, and she yells, "Oh, girl, you gotta hear this one." A man was arrested for running a theme park, and when they said, "Where's your license?" he said, "My dog ate it." Oh, you can't make this shit up. Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on her Prosecco, makes fun of all the weirdos, and then I hear her shout, "Girl, you gotta hear this one." Mama loves to laugh at how absurd life is, says it's all a comedy and I'm her audience. And I love the way she makes fun of the world. She said, "You'll never guess who's with their girlfriend. It was a man who didn't get us out of the bed. He said, I've been through hell and now I need some help. You just can't make this shit up. You just can't make this shit up." Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout, "Girl, you gotta hear this one."
Hey everybody, what a time to be alive. I'm so glad I changed the show format on a week when I decided to be on death's doorstep. Excuse me while I pop a cough drop. I'm feeling much better than Sunday. If you caught the live stream on the other channel, God rest our soul that we made it through that without collapsing into a heap of, I don't know what the hell was happening on Sunday, but it was happening. Anyway, Sunday's live stream will be re-uploaded in shorter videos going a deeper dive into that topic. And I will be taking that one and privating it for when you watch it, what will become apparent as oh so obvious reasons. But remember, it's a very sensitive topic we talked about. And today we are covering the Tyler Robinson hearing that happened at noon. I never know how long these things are going to last, so I always like to do them either later in the day or the next day, because I feel like I waste less of your time and my time. But I hope everybody is doing well today. We are going to get into this hearing. This is going to be a relatively short stream. It's only a 45-minute hearing. It's talking about whether the judge will remove the Utah County Prosecutor's Office. And TLDR, if you haven't been following this case, this is Tyler Robinson, the accused assassin of Charlie Kirk. Yes, I liked Charlie Kirk. I didn't agree with him always, but remember, he is a human being who was unalived on camera in front of thousands of people. Second, we don't bring politics or your political opinion into this chat unless it is a stream designed for that, and this is not it. And three, remember all the conspiracy theories, the FBI not doing enough, this and that. At the end of the day, Charlie Kirk was, one, a civilian, and secondly, he was killed in a school, a state school. With that being said, this is a state case. This is not a federal case. So at the end of the day, although Charlie knew people in high places, he was just a civilian and will be treated just like any other person who was unalived in the world, in our country. So with that being said, leave your conspiracy theories at the door. I don't want to hear them because I don't care. We are not here for drama. We are here for the facts. And at the end of the day, I really don't give two shits about drama unless I'm the one bringing it, i.e. lips, i.e. bubbles, i.e. fleece of the cat. And I say the cat because I have another word for that is not YouTube appropriate. So it's one of those situations where I've had multiple people, and I'm just going to give you a little FYI before we get this started. I've had a couple people send me documents and shit and tell me, am I watching this person's stream? Am I watching that person's stream? The answer is no, because unless I'm the one bringing the drama, and I am the drama, I don't care about shit that I have nothing to do with, and I really don't care for watching so-called grown-ass people acting like children on the internet. I have secondhand embarrassment for people. I have a really hard time with secondhand embarrassment, and I'm embarrassed for like half of YouTube right now. So if it ain't the facts and it's this person did this, I don't give a flying backside. Let's put it that way. And especially when people that are writing me and DMing me, am I watching what? Don't even like me. I've got screenshots of a certain person saying that they don't like me and that this and that, and then they're DMing me like we're buddies. We are not. FYI. So if you happen to catch this, which you probably won't because you don't like me, so you don't watch my streams, we're not friends. Stop DMing me. Anyway, let's get into this because it's just, you know. All right. And this is Judge Graff. He is a relatively new judge when all this happened. And Annie, thanks for getting us started with 5 gifted Squid Pro Quo memberships. As always, I appreciate you. And with cutting down my live streams, there will be more members-only content, members-only streams, hoping to get rid of or get some videos up. Also, it's giving me time to subscribe to my other channel and focus on the channel that I actually enjoy a lot. This one's become a bit dramatic. And once again, I will only be talking about a certain drama case once a week, if that, because I'm kind of over it and I don't care. With that being said, let's get this started.
Is now in session.
Yep.
Calling case number 251-501-576, State of Utah versus Tyler Robinson. Counsel, could you enter your appearances, please?
Your Honor, Christopher Ballard, along with Chad Grunander, Lauren Hunt, and Jeff Gray, the Utah County Attorney, all on behalf of the state.
Good morning.
That's one hell of a lot.
Richard Novak, Stacy Visser, and Michael Burt for Mr. Robinson, who is participating by audio from the Utah County Jail.
Thank you. Good morning to you all.
Thank you.
Mr. Robinson, can you hear us?
Yes, I can, Your Honor.
Thank you. Good morning to you, Mr. Robinson. And to the remaining attorneys that are online as related to this case. Mr. Judd.
Good morning, Your Honor. Michael Judd on behalf of the Media Coalition.
All right. Good morning to you.
Holy crap, turn your volume down, sir.
Right. Before the court turns to the defendant's motion to disqualify Utah County Attorney's Office, there are a couple of preliminary matters the court wishes to address. First, in respect to discovery to the state, the court would appreciate a brief update on the status of discovery disclosure.
Grunander can give that update.
All right, Mr. Grunander.
Judge, I'm looking at an email from our paralegal from 7 days ago, a week ago, and we have received additional files from law enforcement since the last time we met. And we have provided, it looks like 88.8%, so 89% of discovery has been disseminated to the defense.
Okay, I'm not one to judge people not wanting to be on camera. There's a whole bunch of people I follow on YouTube who never put their face on camera. Totally fine. However, personal opinion, a hill I'm willing to die on. If you are in a Zoom court case, your ass better be on camera. If you're in court, your ass better be on camera. Am I wrong?
You are still actively working on this.
Thank you, Mr. Grunander. Defense, did you want to weigh in any way?
No, Your Honor, I don't think that we need to weigh in. We're in the middle of scheduling what I would call a meet and confer with Mr. Grunander and his colleagues concerning outstanding discovery issues. And that's all I can really say at this point.
All right. Thank you, Mr. Novak. I appreciate the efforts by the parties to meet and address these issues. Second, I wish to address the recent actions by this court. Yesterday afternoon, the court issued several orders and would invite the parties to familiarize themselves with the recent orders of the court. The first, standing decorum order effective February 24th, 2026. Second, order on February 3rd, 2026, hearing transcript. Next, standing order on redacting and filing transcripts. Next is the granting news media's motion to amend standing order for Rule 4-202.04, notice of motions for classification. Next, granting news media's motion for attorney's eyes only access to closure motions. And finally, amended standing order, which addresses procedures to classify a public record as non-public. Next, let's turn to the ruling and order on defendant's motion to disqualify.
Jeffrey, the defendant being on camera is not my thing. That's not what I meant. That person was one of the lawyers. If you are a lawyer on a Zoom call, your butt should be on camera. Unless you are in a hospital and on death's doorstep. Your butt better be on camera. And the fact that this judge has standing decorum orders, and which I can appreciate all his standing orders and he updates them every hearing. I have a really difficult time with, I don't care if you're a defense attorney or you're a prosecutor. I don't care if you're the lowest legal assistant known to man. If you are in a court hearing via Zoom and you are there for a reason, your butt better be on camera. If you're a freaking paralegal and you're presenting a document, your butt should be on camera. I don't care. That's a hill I'm willing to die on as far as a decorum. And the fact that this judge has decorum orders and doesn't include that in his decorum order, I find very tacky.
By Utah County Attorney's Office. The court appreciates the patience of all parties with respect to this motion. The court has taken the necessary time to carefully review the motions submitted, consider the evidence presented, and the arguments made by counsel. And the court now reads its ruling, which will be made available and posted later today. Before the court is defendant's motion to disqualify Utah County Attorney's Office. Defendant argues that high-level prosecutor assigned to this case has a concurrent conflict of interest, and because no efforts were made to screen him, the entire office should be disqualified. Because defendant has not established a factual basis for a finding of conflict of interest or an objective appearance of impropriety rising to a constitutional concern, his motion is respectfully denied. At defendant's request, the court held an evidentiary hearing on January.
Okay, so before we get into what the judge describes his order, the Utah County Prosecutor's Office is not disqualified. I'm kind of, I understand, and this is where sometimes what we think is ethically right and morally right is not always, or legally right. And this is where we have to separate out our emotions, and I feel like they should be disqualified, or I feel like he should have disqualified himself. And does the law actually state that he needed to disqualify himself? And because of one attorney in the office, does that disqualify everybody? According to the judge, it does not. So remember, just because we don't like a decision, and I'm not sure how I felt about this, my opinion kind of swayed back and forth, seeing and hearing more things. However, there's people have a very strong opinion on this case, one way or the other, as people generally do, as demonstrated by the case that shall remain nameless. This has garnered a lot of drama and unnecessary drama. But there is and I've said this before and I will continue to say it, there is a difference between what we think is morally and ethically wrong and should be handled, and what is legally wrong and needs to be taken care of by the court. Ethically, I feel like he should have, but that's my ethics. My ethics and the state bar ethics are different. Okay, denied because it wasn't laid out in the wording of what the problem is. It's ridiculous if things aren't worded to someone's satisfaction. It's disregarded. And that is why when I'm seeing enough motions and things that I thought should be approved or I thought should be denied, especially judges who are strictly go by the letter of the statute. You almost need to have the statute in front of you when you are writing the motion. And I don't know how these motions are written. I'm not a lawyer. I don't claim to be. However, it's like when I was writing a report in college and I literally have the information that I was like the rubric of what my teacher was looking for right in front of me while I'm writing the paper. I'd have the rubric either printed out or on my screen while I'm typing, so that I can hit every highlight and everything that teacher or that professor was looking for. Think about the professor being the judge. I would want the statute out in front of me, so I'm one, not having to go by memory, and I'm two, making sure I hit everything in that statute and not just highlights. What's up, Angel? You gotta go pee? Okay, go. I will let this play and I will be right back. Gotta do mama duties.
16th, 2026, and February 3rd, 2026. Each witness was subject to direct and cross-examination, and each witness testified credibly. Although there were slight variations in their testimony about some facts, those variances are not material to the resolution of this motion. Based on the evidence presented, the court makes the following findings of fact. Chad Grunander, a prosecutor assigned to this case, is the chief deputy at the Utah County Attorney's Office. He is a veteran prosecutor and has more experience than any other person in the office litigating homicide cases. On September 10th, 2025, Mr. Grunander's daughter, hereinafter referred to as daughter, attended a rally at Utah Valley University featuring Charlie Kirk. She sat in the back of the university courtyard, approximately 85 feet away from where Mr. Kirk was speaking. Shortly after the rally began, she heard a popping noise and heard a man say, "He's been shot." She, along with other members of the crowd, ran out of the courtyard into a nearby building. Daughter felt afraid for her life while she was running, but felt better when she reached the building. Daughter texted her father. She told him someone was shot. She heard it was Charlie Kirk. She heard the gunshots, and she was okay. Following the incident, daughter had not experienced any trauma, emotional difficulty, or changes to her routine. Daughter was not interviewed by any member of law enforcement or the prosecution team until after the current motion was filed. When Mr. Grunander received the text messages from daughter, he was startled and concerned for her welfare. but he felt better when she notified him saying she was okay. Mr. Grunander shared the text messages with the Utah County Attorney, Jeff Gray. Eventually, each prosecutor on the prosecution team and at least some law enforcement personnel became aware of Mr. Grunander's child had attended the rally. No effort was made by the Utah County Attorney's Office to screen Mr. Grunander from the case or from speaking about his child's experience with other attorneys in the office. Mr. Gray consulted with his prosecution team, including Mr. Grunander, when determining which charges to file and whether to seek the death penalty. But the ultimate charging decision rested solely with Mr. Gray in his statutory capacity as elected county attorney. He made the decision to file a notice of intent to seek the death penalty at the inception of the case rather than waiting until after the arraignment, as allowed by statute. His decision to seek the death penalty was based upon his assessment that the death penalty is appropriate in this case. He chose not to wait to file the notice because he believed it would cause unnecessary speculation on the part of the public and angst on the part of the victim's family. Lauder's presence at the rally did not materially influence Mr. Gray's decision-making, and the court finds that this conclusion is supported by credible testimony and objective record before it. Approximately 3,000 people attended the rally at Utah Valley University. Throughout the course of the investigation, over 40 attendees voluntarily provided witness statements to law enforcement, and several attendees provided video footage of the incident. No evidence was provided by daughter that she was not available from other sources. The state has chosen not to call her as a witness in support of its prosecution of Mr. Robinson. In October 2025, Mr. Grunander sent an email to defense counsel and disclosed his child had attended the rally at Utah Valley University, where Charlie Kirk was shot. Defendant moves for disqualification under Rule 1.7 of the Utah Rules of Professional Conduct, which provides in relevant part that a lawyer has a concurrent conflict of interest if there is a significant risk that the representation will be materially limited by a personal interest of the lawyer. In applying this standard, the court is mindful that this is a capital case. The decision whether to seek the death penalty is among the most solemn exercises of prosecutorial discretion, and allegations of bias or personal influence in that context warrants careful and searching judicial review to preserve both due process and public confidence in the integrity of these proceedings. Defendant argues that Mr. Grunander's relationship with daughter creates a significant risk that his decision-making will be and has been materially limited by personal interest, namely his loyalty to his daughter. Because no screen wasn't.
Okay, back up just a second. Now I understand why that lawyer wasn't on camera, because it's him that they're talking about. But that still doesn't make any sense to me, and here's why. You can easily Google the Utah County Prosecutor's Office and get names and pictures of everybody in that office. This related to you specifically. So either you don't put your name out there and everybody puts or redacts your name for privacy, or you put yourself on camera. My thought process is you are the reason what we are here. You are a grown adult. Your daughter or niece or whoever should remain private, but at the end of the day, your name is out there. Your picture is easily identifiable by a simple Google search. Your butt should be on camera. And yes, good, but writing things out can be difficult for some. Well, here's the thing, Devil Fan. You're not a lawyer, so the difference between you speaking and you writing is not relevant because you're not a lawyer. But lawyers have that expectation that writing and writing motions is the vast majority of their job. So if you cannot write an effective motion for what a judge sees or for what a judge wants, and you know that this judge wants things a certain way and rules a certain way based on the letter of the statute, then you need to be the one to stop writing these motions and let somebody else do it. Because you are not the most effective counsel. I get that for the average person, but we are not talking about the average person here. We are talking about a person with a high level degree who generally walks around society thinking that they're better than the average person. Remember, most politicians are lawyers. So you can kind of get that attitude of what a lawyer walks around with. And I'm not saying all lawyers are like that. Like, look at Larry Foreman, look at Andrea Burkhart. There are lawyers who are completely down to earth and nice people, rackets. If you know, you know. But the general lawyer spends 95% of their day researching and writing. So if you cannot write an effective motion for what a judge wants, that's not the judge's problem. That's not a law problem. That's a lawyer problem. Like, I'm just saying, like, I understand where you're coming from. I really do. But you're not a lawyer. Lawyers are supposed to be held to a higher standard than the rest of us. Hence why they walk around thinking that they're better than the rest of us. Yeah, it's not the judge's job to decipher what a motion means. If you can't articulate the reasoning in the motion, then they can't expect to guess. It's not his job. And Kasha, thanks for the $2 super chat. Hope you're feeling better. I'm here. I'm feeling better, but just better than death is relative, you know? But thank you for the $2 super chat. It is appreciated. Whoop. 1 star. There we go. I hear you. It just says that some people can write presidential speeches but can't talk to save their lives. But I guess that's why their firms are so each can specialize. Exactly. And then when you have a firm like these defense attorneys, most of them are from California. So like they have firms with multiple lawyers. And if you think that another lawyer might be better at writing a particular motion, get them to file a pro hoc vice motion. Get on the case and have them do it. Part of being a good human is knowing what you're good at and knowing what you're not good at. And being able to say, this might not be my area of expertise, or I'm having a hard time writing this where I think the judge will approve it. Can someone else help me, or can someone else do it? So, yeah, isn't that why they hire paralegals for too? Yes. Yes. I don't have my phone on me. I have to go get it. It's somewhere in my house. I think it's in the kitchen. I'm not sure. I was making the little lunch before I did this. So, yeah. I'm sorry. I didn't get to mute myself. I can understand Rob is like, how are you? I said, feel like I was ran over one time by a Mack truck. Yeah. Oh yeah, I slept till like 10 o'clock today. Like the little actually let me sleep. I woke up and she was like sitting there just chilling out. And I'm like, okay, thanks for letting me sleep. Nanny, thanks for being a member for 3 months. Happy birthday to Idol. Yes, happy birthday to her. It is the boss mod's birthday. And I know she's not a huge like advertising that. So we'll you know. Yeah, I gotta go incognito for 15. Please take the lead. All right, I'm gonna start this and I'm gonna go run and get my phone just to see that.
Place to prevent Mr. Grunander's conflict from tainting the entire prosecution team. Defendant argues that Utah County Attorney's Office should be disqualified from prosecuting this case. This is especially so because Mr. Grunander holds a supervisorial role in the office and is a key part of the prosecution team. Defendant has not identified binding authority establishing that a prosecutor has a concurrent conflict solely because the prosecutor has a familial relationship with the potential witness, particularly where the witness has no unique relevant information. In the cases defendant cites, the prosecutors were split between their loyalty to the government and their loyalty to the defendant, or a personal interest separate from the case being prosecuted. In State v. McClellan, the prosecutor had previously represented the defendant and had access to confidential protected information, which could undermine the defendant's right to due process. In State v. Balfour, the prosecutor had past financial, business, and political ties to a defendant, which could conflict with the prosecutor's duty to pursue justice and represent the government. In Wright v. United States, the prosecutor's wife was the defendant's political opponent whom she had accused of sending people to assault her. In State v. Tate, the prosecutor had been a judge on the defendant's case and had been privy to ex parte communications. In People v. Connors, the prosecutor was both a victim and a witness to a separate crime committed by the defendant, which created a personal grudge against the defendant himself. Each of these cases involve a personal interest directly connected to the defendant or some other interest that materially limited the prosecutor's representation of the state. By contrast, the record here contains no evidence that Mr. Grunander or any member of his family had a personal relationship with, bias toward, defendant, nor does the record show that Mr. Grunander's professional judgment has been or is substantially likely to be materially limited by his loyalty to his daughter. Speculation regarding potential influence is insufficient to establish a significant risk under Rule 1.7. The court has independently reviewed the evidentiary record with particular attention to whether any direct or indirect decision-making in this case reflects personal involvement inconsistent with the objective prosecutorial judgment. The court finds no such evidence. Defendant argues that two prosecutorial decisions could have been
interesting that there's no evidence. I mean, I particularly think there is. There's evidence of some wrongdoing, but I guess it doesn't meet the letter of the law. And this is where you will see, I know that people on both sides are going to have very strong opinions about this. People are going to have very, very strong opinions of this. And this is where you got to write things very specifically. You have to be very clear about everything. The case law has to be on point, and that's where I don't have access to Westlaw. Looking up the case law is very time consuming and difficult. Not even ChatGPT can really help me with that, unless I'm using a wrong prompt. This is where what we think totally morally and ethically doesn't always align with what is appropriate. And Jeff Grady, thanks for the $100 Ko-fi. Jesus, Pete, man, I don't know what I would do without your support. I don't, it's greatly appreciated. It leaves me speechless every damn time. And when you can leave someone like me speechless, that says a lot.
Been impacted by Mr. Grunander's relationship to daughter, thereby affecting defendant's due process rights. The decision not to call daughter as a witness and the decision to seek the death penalty. The court is persuaded by the evidence presented that daughter is not being called to testify because she has no uniquely relevant testimony to give, and the state has access to much stronger evidence from other witnesses. To the extent defendant believes his due process rights are violated by the state declining to call daughter as a witness, defendant has subpoena powers and a right to call her himself if he believes her testimony is important to his case. As to the decision to seek death, the court finds that daughter's presence at the rally did not factor into the prosecutorial analysis. The evidence supports that Mr. Gray's decision was grounded in his assessment of the facts and applicable law. Because the circumstances of every case are unique. Oh, I heard something. I'll continue. Let me start over on that sentence. Because the circumstances of every case are unique, prosecutorial discretion allows a prosecutor to consider a host of relevant factors when determining whether to seek death, as long as the considerations of those factors is constitutionally sound. Even if Mr. Gray considered the impact on daughter when deciding to seek death, defendant has not shown that the impact of the crime on victims, witnesses, or even prosecutors themselves is an unconstitutional consideration when deciding to seek the death penalty. In sum, the court concludes that there is not a significant risk that Mr. Grunander's loyalty to daughter has or will materially limit his representation of the state of Utah. Furthermore,
Well, as far as I know, this prosecutor isn't actually on the case. That's the interesting part about this. He's just in the office and he's a supervisor. He is not actually on this case. That was an interesting point about all of this. But I do think that he should be left out of everything. Just for optics, you don't need to have a hand in this. Your other people can do it. Just don't touch it. Don't touch anything to do with this case. It's as tempting as it is. You are too close personally. And whether that can be seen as an ethics violation or not, to me, it's too much of a emotional thing. And even though I do tend to get emotional, as we saw on Sunday, when it comes to making decisions like this, and if I were a lawyer in this case, the less emotion that I can, the less emotionally invested that I can get, the better. And that's one of the reasons that I don't watch other content on the same things I'm covering, because I don't want to get emotionally invested, especially in a topic where so many people are emotionally invested. Because when emotions get too involved in things, your logic and your common sense tends to drop. So if I were of that office, I'd be like, you don't go anywhere near this case. You even step foot in the room during this case, and I'm gonna stop talking. It's just an optics thing, and yeah. Shush. Yeah, emotional investment destroys your sensibility. Yeah. Oh, I'm not squid type of sick, but working through it. I hope so too. I really hope so too. I hope the best. And if you are the praying type, pray for our friend Jeff Grady. He could use it too. But yeah, we don't want to get too emotionally invested in everything, because that's when logic and common sense start to go down the drain. And I don't like Tyler Robinson at all, but there's the people who are emotionally invested and think that this was all a setup will tell you that this judge is biased. The people who are super pro Charlie Kirk and think Tyler Robinson is the devil will be, this is great, this is good news, but this judge is not biased, but just wait until they get a decision that the pro Charlie Kirk side doesn't like. You will see people calling this judge biased. That is how I know people are making decisions based on how they feel and not the logic of the situation. That's just my personal 2 cents.
It has not shown that there is a significant risk that Mr. Grunander's relationship with daughter has or will impact defendant's due process rights. Based on the record before the court, defendant has not shown that his prosecution by the Utah County Attorney's Office is tainted by a concurrent conflict of interest under Rule 1.7. During oral argument, defendant requested the court also consider whether the Utah County Attorney's Office followed the process recommended by the Utah Prosecutor's Best Practices created by the Statewide Association of Prosecutors, otherwise known as SWAP, in determining whether to disqualify the Utah County Attorney's Office. Defendant argues that best practice demands that a prosecutor avoid the appearance of bias based upon public perception. To avoid this appearance, the Utah County Attorney's Office should have immediately screened Mr. Grunander from the rest of the office. Because it failed to do so, there is now a hint that the decision to seek the death penalty was an emotional response to Mr. Grunander's concern for his daughter. The best practices document is not controlling on this court. And even if it was, the court is unpersuaded that Mr. Grunander's relationship with daughter creates an appearance of bias in this case. Prosecutors need not be immune to the emotional response of others to prosecute a case. Indeed, it is part of a prosecutor's duty to interview witnesses and victims and evaluate the impact of an alleged crime. A prosecutor need not be disinterested on the issue whether a prospective defendant has committed the crime with which he is charged. If honestly convinced of the defendant's guilt, the prosecutor is free, indeed obligated, to be deeply interested in urging that view by any fair means. True disinterest on the issue of such a defendant's guilt is the domain of the judge and the jury, not the prosecutor. And this is citing from Wright. Also, prosecutors.
Jeffrey, I tried to type this in a comment, but apparently YouTube is screening my comments today and telling me that they rejected it because it might be spam. I made this girl chicken. I gave her a little bit of chili, among other things, on her plate, and she still took my protein bar.
Need not be entirely neutral and detached. In an adversarial system, they are necessarily permitted to be zealous in their enforcement of the law. After reviewing the record, the court concludes that the familial relationship at issue, without additional evidence of personal involvement or influence, does not create a reasonable perception that the prosecutorial discretion was exercised for improper reasons. Zealous advocacy remains bound by constitutional and ethical constraints, and the court finds that those boundaries have not been crossed here. This ruling is confined to the specific facts established in this record. Different circumstances, such as evidence of direct personal involvement, uniquely material testimony, or demonstrable influence over discretionary decisions, could warrant a different result. In sum, the defendant has not shown that there is a significant risk that Mr. Grunander's loyalty to daughter has or will materially limit representation of the state, nor has defendant demonstrated that his due process rights are compromised by the continued prosecution of this case by the Utah County Attorney's Office. Applying this governing legal standard to the facts established in the record, defendant's motion is respectfully denied.
I've tried to type 3 comments into the chat and YouTube has rejected them all. I thought it was chicken skin that I couldn't use on YouTube, but apparently I can't because it wouldn't reject it. Is the judge talking about his opinion or is he stating the defendant's motion? Well, here's the thing about it. He is doing both. Because this is a hearing and not an order written down, he is telling you the defendant's motion, what was in the defendant's motion, what they argued, and why he's denying or why he's accepting or denying it. So he's talking in a logical sense of, here's what they said, here's the argument they used. I don't find that argument is worth it. Here's why I don't think that argument is worth it, and here's my ruling. So there's nothing can be taken out of context. Everybody knows exactly what is on the page. And this is why I like this judge, because here's what they said, here's what they wanted, here's the case law they used. I found that wasn't appropriate, and here's why I found it wasn't appropriate, and so this is the sign of what I believe is a good judge. Probably not till next year. Probably not till next year.
All right. That order in a written form will be available shortly online. The court wishes to turn to its last matter, and and the court wishes to address the remaining outstanding motions in a timely manner and to set appropriate dates for their hearing and resolution. The court recognizes that coordinating schedules can be challenging and that we all make a good faith effort to accommodate the court and one another in setting these matters for hearing so that the constitutional rights of all parties are protected and preserved. Counsel, I'm reviewing a list of motions before the court, and so I wish to quickly address that, set hearing dates so all parties have an expectation of what comes next and what to prepare for. And so I'll turn to the attorneys. The court has thoughts, but I want to hear your thoughts first.
I really do like this judge.
Judge, this is Mr. Grunander. I apologize for my camera. Something's happening with it this morning, but
Sure.
Okay, we got an answer. Supposedly. I don't know if I believe that, but you know.
I see that the court entered a couple of rulings that we received late last night. I think there are still the outstanding motions to classify as private that need to be addressed. And then there is the outstanding motion from the defense to exclude media, electronic media coverage. And there is a request, and I'll defer to the defense, but there's a request for an evidentiary hearing there. But that's what I see as far as what's outstanding. In addition, Your Honor, I should say there is one with respect to a piece of evidence that we're trying to identify additional reports on to get to the defense so that we can be fully prepared to address that issue.
All right. Thank you, Mr. Grunander. Attorney.
And no, I believe that they wholeheartedly believed that this was an ethical violation and they wanted this moved. I believe that they wanted it moved. What was not explicitly said, it kind of was, but I have to go back and reread the motions. I haven't read them in a while. They were trying to get the trial moved for good reason, because in that county, that county is where the school is. That county is where thousands of people watch someone be unalived. The possibility of him getting a fair trial is harder. It's not impossible. It happens all the time. However, it's harder. So they were getting everything they could to get it out of that county with the hopes of taking away the emotion, because if it gets moved to a different county, those people might not have been there to witness it. Whereas that county is personally affected because Utah County became the center of the political world for a hot minute. I believe they were doing everything they could to try to get it moved, not only for the fair trial aspect, but the emotion. Would the defense now try to remove the judge? I don't think this one will, because this judge is very plain in explaining why he's doing it and what he's using to make his decision. Where I think some other lawyers, if it was Bubble Brain or any of those fucktards, excuse my language, I believe that they would. If it was Lips, she would, because she's done it for less. However, I don't think that they will, because these lawyers seem to, although they're arguing and doing everything they can for their client, they're doing it in a professional manner.
To defense.
Thank you, Your Honor. This is Richard Novak. The court may have seen the emails which were exchanged with the court's clerk and counsel concerning scheduling. We had all suggested a date that the court was available to resolve the
She brought it back. I guess she was done.
The classification issues, some of which, as Mr. Grunander said, are still pending, notwithstanding yesterday's orders. And that was the date of April 17th. It was our expectation that the court would take care of the classification issues at a hearing that afternoon. The court's public order yesterday did address in a footnote a question of the media's standing with respect to, say, the merits of the motion that Mr. Grunander mentioned. So we think that that needs to be addressed because the media did file what they purport to be a preliminary response to a motion that is presently classified. So before we actually before the court conducts the hearing on the merits of the motion to exclude, which we anticipate would be an evidentiary hearing with both exhibits and witnesses, we think that it would be most efficient for the court to lay the groundwork on what will be public, what will not be public, and which entities, I'm not going to say parties because that's not right, which entities have standing to weigh in on that motion and the scope of that standing. And we do think, because the court has obviously seen, because it approved the filing of the initial motion, that there's an extensive evidentiary presentation that's necessary. It's not going to be the 2 to 3 hours that we were told the court is available on April 17th. So our thought is that we would have all of that sort of preliminary and standing, all of the preliminary and standing issues resolved at the court's next availability that worked for counsel, which is April 17th, and that at some date after April 17th, we would then have the hearing on the merits of that motion.
All right. Any other questions?
Does that make sense, or did I just muddy it up even more?
No, I understand what you're saying. Any other input from any of the other parties before the court gives its input?
I think Mr. Novak mentioned the afternoon of April 17th. I think the court's availability may be that morning. And other than that, I think this plan sounds good and makes sense to the media. I think the remaining issues that are most likely to be argued and resolved at an April 17th hearing are individualized motions related to closure of things on the docket. In that way, there's kind of a commonality between those. There's likely some overlap, even though they're separate briefings, on the interests and the questions related to those motions to classify. I'll note that more may come along. There was a reply to the motion to exclude cameras from the courtroom that has also been subject to a motion to classify. But again, I think that could be argued easily alongside the pending motions to classify or close that the court is attempting to schedule for hearing now.
All right. All right, so here's the court's input. I wish to address the motions to classify and addressing the closure of the hearing or the evidentiary hearing to exclude media well before April. And I don't believe that those hearings will take a lot of time.
Okay, Snipe, Potty Mouth Squid. No, I literally said, please hit the like button, and YouTube rejected my comment. I said in response to Heidel saying thanks for the gen update, didn't think it was appropriate to stop the stream because of it. But I tried twice to put, she messaged me this morning giving me an update. YouTube rejected that comment not once, but twice. YouTube won't let me talk to my own chat. Yeah, and Devil Fan, I tried to put a comment towards you. That's why they tried to get the prosecutor's office disqualified, because if they did that, they could move it to a different county and different venue, which is one of the reasons that I think they did that instead of just going, we want it, because I know the judge would refuse to, just because it's a high profile case, to move it to a different county. So they tried to use the Utah County Prosecutor's Office. This is just my opinion. I'm not in their little powwow meetings. I'm not a fly on the wall in their office, but that's what I feel like they tried to do, because they knew the judge would just say no to change of venue. Because there's other high profile cases that are constantly being tried in this country that do not get afforded a change of venue. Sarah Boone tried to get a, like, for example, high profile case. Anthony Shea, high profile case, not moving out of Orange County, Florida. Alec Murdaugh, tiny ass town in South Carolina, which is actually not that far from here. I have to drive through that town on my way to Charleston every time. Not moved. High profile case, small town, still didn't get a change of venue. With that being said, that's why I feel like they tried to get the prosecutor's office disqualified, so that they could move it without really moving it. It was their sneaky, underhanded way to do it. So, hey, Ninja Puppy, how are you? Your comment about YouTube keeps directing my comment makes no sense. Doesn't let you put under comments. Yeah, I know, right? It lets me rag on YouTube and call YouTube an asshole, but it won't let me. It won't let me type regular comments. That, yeah. I just, yeah. It will take weeks for parties to interview and agree on 12 jurors. Danny Rollins murder case in Gainesville took nearly a month. Yeah.
And for this court, for many reasons, and because the court intends to keep the May preliminary hearing, and I realize that there may be things that come up that may affect that, but as we stand today, that preliminary hearing date is set, and I wish for these issues to be addressed prior to the preliminary hearing, given the nature of that hearing, and so there is clarity on what will happen. What dates do we have available in March? In council, before I get these dates, I recognize that you all have challenging schedules, but this case must have priority as this court is trying to balance the constitutional rights of all parties and being timely in its process. So I ask you respectfully to do your best to ensure that we can align to a schedule that allows us to move forward in a proper manner while respecting the constitutional rights of all parties. And so looking at March dates, I have March 13th. It's rare, available all day. And I want to preface this by saying, just to give you an idea, when I am setting a hearing for an hour or more, I'm looking into June just because of the court's calendar. And so this is a rare opportunity to have this to address the motions to classify and potentially closure. What does that look like for the parties?
On the 13th.
Thank you.
Your Honor, I think, this is Richard Novak. I think, and I would defer to Mr. Judd, but I think one of the attorneys of record for the media entities had a problem with March 13th when the clerk initially floated that date, but I may be wrong about that, and then I can address the defense's availability on that date.
Well, I wish to address defense's availability first.
Okay, so I thought that I needed to be on the East Coast for a personal matter. I could probably work around that. The only other conflict we had was that Ms. Visser was scheduled to start a serious felony matter the following Monday morning, the 16th. But we hear what the court's saying. So I can adjust my personal travel schedule to accommodate the court. And I appreciate that the court wants to take advantage of this rare vacancy in its schedule.
Right. Thank you, Mr. Novak. I appreciate that. Mr. Judd.
Your Honor, does the court have a view right now as to whether this would be an in-person hearing or something that could be argued by WebEx?
I will accommodate the parties, and of course, turning to defense, and their preference is important, whether they request in person or via WebEx, or maybe it's mixed. Maybe some of us appear via WebEx. Well, not the court, but us. So I am open to try to find a solution.
I'm curious about that, Your Honor.
Could you imagine the court and the judge appearing via WebEx? How in his living room. Like, come on. So far so good. However, the judge is very strict with the media, because every time the media gets zooms in on his face, every time the media zooms in on Tyler Robinson's face, the defense gets bitchy. So it's supposed to be, but we will see if whoever is doing the pool feed, their camera operator, cannot piss off the defense. But we have 42 people here and only like 26 likes. Can we like get that number up a little bit? Because I'm doing this. We're not. I'm trying to do some of the smaller stuff, and I'm not trying to do things that will just get me views, because I know there is a certain topic I could talk about that'll get me 1,000 to 2,000 views on every video. Even though I love that, I'm not that kind of person. I cover what I want to cover, and so I'm trying to do this and give y'all my 2 cents from a prospective jury member, not so much a lawyer's perspective, because yes, lawyers have a good perspective based on their knowledge, but I'm a jury member, and this is what I see as a prospective jury member. It's an interesting viewpoint, because I'm not a lawyer and I don't want to be. Yeah, lurkers, hit the thumbs up or F you and hit the down button. Either way. No, I'm typing thumb. They're just not going to. They're just not going through. And if I refresh, we go back to the beginning of this hearing, and I really don't want to do that.
But it's not outcome determinative. We will make it work. We realize we're guests in the court, that these issues are important. We recognize the interests that are in play. I'm scheduled to be elsewhere in Chicago that day. I'll appear by WebEx if that's what the court allows. If not, then I'll move those plans. This is a priority, and if that's the time that it works, then we'll make it work.
All right. So the parties, first, is it the intent to be in person? And if so, what are the thoughts about Mr. Judd appearing via WebEx?
Your Honor, the state is open to any procedure that will allow us to have this hearing on March 13th. We can be in person or via WebEx, and we have no objection to other entities, representatives appearing in whichever way is most accommodating for them.
All right. Thank you, Mr. Ballard. Mr. Novak.
All I would say is that if the court is going to open up a WebEx for some participants, we will be there either in person or by WebEx or both, because there are, as Your Honor knows, a few of us. Ms. Nestor will not be present because she's already engaged in trial in another county. But we will, I guess what I would say today is that we will be appearing in person, present in court with Mr. Robinson with us. If there is some reason why one of us needs to appear remotely, then we'll address that with the court.
All right. Thank you, Mr. Novak. So it sounds like we're going to go ahead and set this in person. I realize that, there are complications, and Mr. Judd, it looks like there is no opposition to you appearing via WebEx. And of course, as mentioned by defense, there are certain attorneys that may need to appear by WebEx. So we will accommodate that, and we'll anticipate Mr. Robinson's appearance in person on March 13th. Counsel, given the direction of the court dealing with closure and classification of motions, how much time will you need to conduct your business in court? I want to open that up and lock it down before that date gets cannibalized by other important hearings as well.
And Ninja Puppy, thanks for the $5 Ko-fi. I appreciate you guys, and thanks for supporting me on Ko-fi. They only take 5%, and where YouTube takes 30%. So thank you for supporting my channel using that and not giving any more money to YouTube, which is being a completely and totally big pain in the butt today because my comments are not showing up on it at all. So it's a thing. And hey, see you later. Gotta go. Everyone have a great day. You have a great day as well. And thanks, John, for showing up. I haven't seen you in a long time. I know the time difference is weird and life and all of that, but I appreciate y'all for being here. But please hit that like button. We have 49 people here. Y'all, and we only have 29 likes. So, and surprisingly enough, we don't have any dislikes. But I know people are gonna bitch about me talking. So, maybe.
Your Honor, this is Mr. Ballard. I guess I would defer to the defense. It's their motions to close and to classify. But I think having a time limit regardless would be helpful.
I'm going to suggest that, Your Honor, that it's going to be more than 1 hour and maybe less than 2 hours. And the reason why I say that is there are multiple motions to classify around the same issues, which are the motion, the reply, and the evidentiary hearing itself. And the court's going to obviously hear not only from the moving parties, which is Mr. Robinson, but the state and counsel for the media. And it would be hard for me to imagine that many attorneys in the court could do all that in less than 1 hour.
Are you commenting on the amount of time attorneys talk?
Only myself. I'm only referring to myself here.
No worries. I include myself in that comment. All right. So let's go ahead and set aside 3 hours just to be safe. I don't want any party to feel pressured, but as mentioned by Mr. Ballard, I believe that setting a timeline is appropriate. So let's go ahead and start. How does 10 a.m. on March 13th look? 10, 11, 12, concluding at the 1 o'clock hour.
That's fine for the defense, Your Honor. That might actually allow me to get to my originally planned destination the same evening, so that's fine.
All right. To Mr. Ballard?
10 a.m. is perfect, Your Honor. Thank you.
All right. And Mr. Judd?
Yes, Your Honor.
All right. Let's turn to the second issue where we have that, I believe it was April 17th date. Does that allow sufficient time to address the evidentiary hearing being requested?
And I'm writing all this stuff down.
In terms of preparation for April 17th, yes, if that's when the court wants to do it, we will be ready to go on that date. That is, if that's what the court means by sufficient time, yes.
All right. And how much time, Mr. Novak, do you anticipate needing? I certainly want to make sure that all parties have enough time to present what they need to present.
You all seriously hit that like button because Snipe Hunter just disliked the stream. I saw it live happen. Our likes went from 29 to 28. Karen, no one agrees with the chat.
Your Honor, I'm going to defer to Mr. Burt on that, if Mr. Burt is able to do so. Looks like technologically he is.
Good morning, Your Honor.
Good morning, Mr. Burt.
Judge, I think on that, because it is going to involve the presentation of extensive exhibits and also some expert.
Why aren't you on camera? You are an effing lawyer. Excuse my language. Why aren't you on camera? You're a lawyer presenting in front of a court, even if it's just to discuss a schedule. As long as you're not a cat when you turn on your camera, turn on your damn camera.
Evidence that we'd be looking at a full day, accounting for cross-examination by all the lawyers involved here.
All right. And to the state, what's your input?
A is more than enough to be able to address those issues.
All right. And to the state. I'm sorry, I just, to any other party. Then.
I will defer to the parties, Your Honor, on this. As the court knows, we haven't seen the motion itself or the reply. We've seen the state's opposition. But I think whatever the defense believes is necessary, given that they are the party bringing evidence and the expert, if they believe that a day is sufficient, we see no reason to push back on that.
All right. All right. I do note that we have other issues on that day. I think we're just going to have to bump them. And
I can appreciate that the attorney for the news media and representing the media is like, we're a guest here, we'll make it work. I can definitely thank goodness for that. They are trying to stay in the good graces of the judge. The defense in this case wants to seal everything. It's like, I'm sorry, this might be a high profile case, but like, unless you have a good reason to seal, court records in this country are a matter of public record, as demonstrated by other cases that I may or may not be covering. Documents in cases in this country are a matter of public record. You can't seal everything just because you don't want information getting out there. That's not how this shit works. And I know the defense has to do everything to protect their client, but at a certain point, it gets ridiculous. And the fact that they're fighting to seal every hearing and they're fighting to seal every document, it's like, y'all are making this harder than it has to be. And it's highly annoying to someone like me who likes to view public records because they are public records. The defense is trying, you can't show them on camera. Welcome to being a defendant in a televised case. They didn't tell OJ that they couldn't film his face. Sarah Boone had her face filmed. She hated it, but guess what? That's just the way shit worked. You can't bitch about every little thing. Well, you can, but at some point, I think this is going to start annoying the judge when they want every little thing to be sealed and they file a motion every time and just clutter the court with paperwork. According to Andrea Burkhart's Substack, sorry, I couldn't find the word. She has 396 entries in this. There's sealed hearing transcript from 210. Return electronic notifications not obtained. The last thing she has in here that we can read through, probably won't be today because of my voice, but is 212 defendant's memo in opposition to media's motion for attorney's eyes only access. You what? Excuse you, sir, or ma'am, or whoever the hell filed this. Your client is accused of a crime that was committed in public. Why should your client get any more privacy than the person that Charlie didn't get privacy when he was shot? So why do you feel like you can stomp all over the court and, attorney's eyes only? Welcome to the US. If you wanted attorney's eyes only, move to like North Korea. I'm sure that it's attorney's eyes only there. Just saying. Yeah, the YouTube approval thing is out of hand. When YouTube is rejecting my comments and I'm the person running the stream, then yeah. So if your comment gets you don't see it, it's not my mods, it's YouTube. And hey, Barbara, how are you? There's only a minute left.
We'll go ahead
on
and
this.
set aside the full day on April 17th. We'll start at 10 a.m. and conclude promptly at 5 p.m. if needs be. But it is the intent that we fully address the issues and it's not carried over or continued to another day. The court anticipates, given what's presented, has been the practice of the court, that it would take it under advisement and schedule a WebEx hearing to issue its decision. All right, so April 17th, starting at 10 a.m. I'm assuming in person, and Mr. Novak, I don't want to assume anything. In person with Mr. Robinson in court?
Yes, Your Honor, exactly.
All right. All right, thank you, counsel. I really appreciate your working together, and I know it's complicated. You all have busy.
All right, that's about it for that. However, just a couple of things. Innocent until proven guilty. We don't have to like him to understand that he is afforded constitutional rights. However, you having a camera on you, Brad Koberger had a camera on him. Innocent until proven guilty. However, you are accused of a crime. Karen Reed had a camera on her face all the damn time. You didn't see her counsel bitching. Yeah. But public records, court documents in this country are a matter of public record. We have that transparency so that we can scrutinize what is happening in our court system, because when things aren't transparent, that's where bullshit happens. So the fact that they're trying to get everything sealed, to me, screams nefarious. I don't think my bleeding heart side and my emotional side wants to say they're doing things in the best interest of their client. However, my skeptical side says you're trying to pull some bullshit and you don't want the entire country calling you out on the bullshit. That's where my skeptical, my cynical side goes. I do have a bleeding heart side. I just don't show it because it's not warranted. See Sunday. Yeah, my snark level refuses to be silent when an opportunity knocks. Yeah. I have to go do mama duties. I will. Oh, all right. But on that note, so I am doing my best to keep emotion out of this because I do have an opinion on this case. However, my opinion and the grand scheme of things doesn't matter to what the court thinks. The court doesn't give two flying Fs about people on YouTube's opinion of this whole situation. So Spawn is never going to believe. Yes, he will. Yes, he will. However, I'm going to see if I can send y'all somewhere instead of leaving you on your own to go about YouTube. I know it's disgusting, but gargle with warm salt water. It takes swelling down in your throat. You just have something to eat right away. I'm going to. And hey, Cynthia, how are you? I have to go to work tonight too. So, I have to go to work tonight. So, oh, and Snipe, if you were the one who hit the dislike button, can you fix that, please? Can you please fix that? You're already there. I'm going to see where we can redirect because a bunch of people are live. Ricada is live doing the Corey Richards day 2. Let's see if Mo is live. Usually Mo in the deep end comes up if she's live, but I don't see anything right now. So Ricada it is. Because Corey Richins is a popular trial. I honestly have no idea what's going on in that case. Oh, Mama Shauna thinks if you caught Sunday night's stream on evidence through motion, my voice then was way worse than it is now. So, but y'all tell Ricada that I said hi and that I sent y'all over there, and go give him a like and a follow. If you don't, have a great day, and I'll see you guys on Thursday. Bye.